So in the 15 minutes I have today, I'm just going to make 3 comments. The first comment is going to be more about some of the implications of the nation-state law. And the second one is going to be about some of the people who oppose the law even though they agree with it, mainly the group of politicians and intellectuals known as liberal Zionists. And the final point, I'm going to discuss why they oppose this basic law. To begin with the basic law itself, as you know, it's a basic law, which means that it is a constitutional law. It's a law that has the power of a constitution, recognized as such by the Israeli Supreme Court. But upon reading the basic law itself, and for anybody who is familiar with the Israeli legal landscape, we'll see that the basic law itself does not really change that much in the legal landscape. What it does mostly is that it reasserts certain principles that have long been part of the consensus among Israeli or mostly Jewish Israeli citizens. And if we'll take some examples to demonstrate this point, we can see that the basic law refers to or declares some of the principles, or refers to some of the principles in the Declaration of Establishment of the State of Israel, mainly the right to self-determination of Jewish people in what they call the land of Israel. But then also we can see that this right has long been established in Israeli law. It is part of the Declaration of the Establishment of the State from 1948. It was repeated multiple times, many times, in the decisions of the Supreme Court of Israel. The only difference that it makes actually here is that the basic law adds a new category, because the basic law talks about exercising natural, cultural, religious, and historic right to self-determination. Now, religious right to self-determination is a new one. So that's the only novel category here. And even if we look at the idea of self-determination, we can see that in Israeli legal scholarship, in the Israeli legal literature, in the decisions of the Supreme Court, and also in the writings of those who are known as liberal Zionists, we can see that when they talk about self-determination, they mean exclusive self-determination of Jews only, which means that in no scenario in the past, the idea of self-determination of everybody who lives in the territory of the State of Israel participates in the right to self-determination. Another example which demonstrates that there hasn't really been much change is the section that relates to language. In Israel, Israel after 1948 adopted mandatory legislation. So all of the mandate legislation, with some exceptions, became part of Israeli law. That also included the relevant sections relating to language. And based on this adoption of the mandate legislation, Arabic was a formal language. But even though Arabic was a formal language, the Supreme Court of Israel said, yes, it is a formal language, but Hebrew is the principal language. Arabic is a formal language with distinct and added value, which means that even though the relevant section in what was known as the Order in Council talked about 2 formal or official languages, the Supreme Court introduced a hierarchy. Hebrew is the principal language. Arabic is an official language. Now, what did the new basic law, do? The basic law talked about Hebrew being the official language and Arabic being a language with special status, which is not really any different from what was mentioned by the Israeli Supreme Court, introducing that hierarchy between the languages. Another example I'm going to mention is the issue related to settlement. So Section 7 of the Basic Law states that the state sees the development of Jewish settlement as a national value and shall act in order to promote its establishment and development. Now, this position, which is now part of the Basic Law, we can see that it is not dissimilar from positions that were presented sometimes in the case law, sometimes in the literature or legal literature, and extrajudicial writings of judges. And here I'm quoting and bringing a quote from Aharon Barak, who was a former Supreme Court Chief Justice, he's seen as a towering figure in academy, who has an international following. Many people cite him as their hero, and he's kind of like a modern day prophet of Israeli liberalism. And in 2002, in the 34th Zionist Congress, he gave a speech where he talked about what makes a state a Jewish state. And he says that it is a state that promotes Jewish settlement and, quote, a state that redeems state land for Jewish settlement. So essentially, what we're seeing here is that the Basic Law just codified or just put into words that are now Basic Law what was an existing legal principle. And to also demonstrate the point that, because one of the arguments is that this is going to increase discrimination, but discrimination already exists in a range of legal strategies that are meant to discriminate without actually officially sanctioning discrimination. So, and there was one decision in the year 2000 that was declared some sorts of discrimination legal, was circumvented by legislation in the Knesset, in addition to the fact that the protection that this decision declared was not really that strong. So this is just to make the point that if we look at the legal situation before, the constitutional principles before the enactment of this Basic Law and the Basic Law, we'll see that they're almost identical. So in the legal sense, it did not really make a lot of difference. Probably politically, it does, or to some extent also it emboldens people, emboldens judges to take certain positions, but the principles have already been there and have long been there. Now the second point I'm going to make is about the category of liberal Zionists, which is a group of politicians and intellectuals who, of course, believe in Zionism, but they try to balance the Jewish-only right to self-determination in Israel with some liberal democratic principles. Of course, which is not an easy task. It's a very complicated task to balance these two. Usually they end with failure, but then the end goal of the exercises, intellectual exercises that they have, is to demonstrate that Israel, despite the fact that it constitutionally favors Jews, the culture, collective rights, and legally discriminates against the Palestinian population, is a liberal democracy. Now, there are a number of ways that they do this, usually either by comparing to other countries, mostly Eastern Europe, or looking at the idea of equality and then analyzing the hell out of it so that equality does not mean equality and discrimination does not mean discrimination, and start going in circles to get to that conclusion. But the end goal, basically, here is just they want to reconcile the values of democracy and Jewish self-determination. Now, most of these people who subscribe to this worldview were opposed to the Basic Law. So we have people like Yuli Tamir, Amnon Rubinstein, and others who are well known in this category who were opposed to it. And even though they're opposed to it, the irony here is that most of these people who are known as liberal Zionists are actually the people who helped establish all of the principles that are now part of the Basic Law. So if we look at people like, for example, Aharon Barak. Aharon Barak is probably one of the most important people who established the meaning of what Jewish and democratic means, and also tried to insert some liberal values in it. And even though, as I said, he's seen as modern day liberal prophet, when the Basic Law was first introduced in the Knesset, we can see that the member of Knesset who introduced it justified the Basic Law by saying that I'm actually taking text from Barak's speeches. So we can see how. So this is one example. Other examples also, the principles themselves. If we look at the literature of this group of people, liberal Zionists, we'll see that most of it is centers around justifying things like discrimination, explaining that discrimination is not really discrimination, why all of the things that Israel does are okay. If there's a problem, then there's a problem that could be dealt with very easily. Now, these same people are the ones who are now opposed to the law, even though we can see that they actually sowed the seeds for this act by basically providing the intellectual cover and the intellectual justifications for all of the elements in the Basic Law. Now, my last point is, so how come they're so opposed to it if we can see that they are actually the intellectual parents of this Basic Law, even though they want to dissociate themselves from it? So if they agree with all the principles, then why they're opposed to it? And why did this Basic Law offend their liberal sensibilities, but other things that the state did not offend their liberal sensibilities? For example, the expulsion of the Bedouin communities in the Naqab. We did not see them being outraged and fighting against it or demonstrating against it when it took place. The acts that prohibit family reunification, we did not see them fighting against it. In fact, they were some of the people leading the justification for it. They are the ones who wrote in legal journals, in books, saying that it is okay. We did not see them also saying anything about the Nakba. We did not see them saying much about the laws that said that participation in boycotts is illegal. So, one conclusion that emerged from their writings is that they're more concerned with image and appearance. So, if we take an example, Professor Amnon Rubinstein, who was the president of Tel Aviv University, a member of Knesset, and also a minister for about 4 years, and also probably one of the most important constitutional law scholars in the country. He says, or he writes, that everyone who reads the bill understands that it will help BDS, the Boycott, Divestment, Sanctioned campaign against Israel, and increase Israel's isolation in the West and within Jewish diaspora. Another example is Professor Shlomo Avineri of the Hebrew University. who was concerned that this law is going to increase the tension in Israel between Jews and Palestinians, but also added that this will be the cause of significant damage internationally. Yael Tamir, who is also an academic and a former minister from the Labour Party, adds that the new basic law undermines Israel's definition as a democratic state and expands the growing gap between Israel and the Western world. So we can see that the main concern is not really the ethno-religious and inherently exclusionary principles and also the entrenchment of Israel's colonial nature and policy. The main problem is that this act actually demonstrates that Israel is closer to apartheid than democracy. It's closer more to white supremacists like Richard Spencer than Martin Luther King. Because this basic law, in 340 words, makes the argument that hitherto one needed thousands of pages to demonstrate. So it's now a position that cannot be compared away, and liberal Zionists have their fingerprints all over it. Thank you.